Welcome to the new sexual harassment training, developed in December 2019. Public Act 100-762 was passed by the Illinois General Assembly in May 2018 and signed by the governor in August of 2018. The law requires sexual harassment prevention training for all persons who hold a professional license issued by the Division of Professional Regulation, housed within the Illinois Department of Financial and Professional Regulation, for professions that require continuing education to renew. The law requires licensees to complete a 1-hour continuing education course in sexual harassment prevention training and is effective for all renewals on or after January 1st of 2020. This continuing education requirement is included in the number of hours already required under the individual licensure acts and rules and does not increase the number of hours required to renew a license in Illinois. The Illinois Department of Financial and Professional Regulation adopted rules in May 2019 to implement the law. Public Act 100-762 was passed by the Illinois General Assembly in May of the previous year. 68 Illinois Administrative Code Part 1130.400 requires the 1-hour sexual harassment prevention training course to include the following topics. 1. What is sexual harassment, including its forms and types? 2. What should one do if one experiences or witnesses unwelcome sexual contact? 3. Reporting sexual harassment within one's place of employment and to outside entities like the Illinois Department of Human Rights. And 4. Whistleblower Protections. So today's learning objectives will follow very closely to the requirements outlined in the Illinois Administrative Code. The first, defining sexual harassment, including its forms and types. The second, identifying how to respond if you experience or witness unwelcome sexual harassment. The third, identify how to report sexual harassment within your place of employment and to outside entities like the Illinois Department of Human Rights. And lastly, understanding whistleblower protections. So why did the Illinois General Assembly take action to pass legislation that requires you to complete a 1-hour training on sexual harassment prevention as a condition of your licensure? In recent years, the Me Too movement has gained a lot of steam. The Me Too movement was founded in 2006 to help survivors of sexual violence, particularly Black women and girls and other young women of color from low-wealth communities, find pathways to healing. The movement gained significant momentum following the exposure of widespread sexual abuse allegations against Harvey Weinstein in October 2017. This is when the Me Too movement began to spread virally as a hashtag on social media, after a tweet by an actress urged women who have been sexually harassed or assaulted to write hashtag #MeToo and share their story as a status on their social media pages. This movement encouraged survivors of sexual harassment and assault to share their stories and come forward to report perpetrators, including those like internationally known actors, TV hosts, athletes, executives, and legislators. Throughout late 2017 and 2018, legislators, staff, and lobbyists in Illinois came forward to report allegations of sexual harassment in Illinois government, both under the Capitol Dome in Springfield and on political campaigns. Some lobbyists, staffers, and legislators shared general stories of past experiences, and some even made very public allegations against specific individuals. This led to the creation of 2 task forces: the Senate Task Force on Sexual Discrimination and Harassment Awareness and Prevention, and the House Sexual Discrimination and Harassment Task Force. In November of 2017, the Illinois Senate unanimously adopted Senate Resolution 1076, sponsored by State Senator Melinda Bush and co-sponsored by 2/3 of the state Senate. This created the Senate Task Force on Sexual Discrimination and Harassment Awareness and Prevention. At the same time, the Illinois House of Representatives passed House Resolution 687, which created the House Sexual Discrimination and Harassment Task Force. The task force was created in response to the nationwide #MeToo movement and in response to an open letter signed by more than 300 Illinois legislators, lobbyists, staff, and policymakers, acknowledging and condemning a pervasive culture of sexual harassment in Illinois politics and government. The resolution outlined the harm caused by sexual harassment and discrimination in both the public and private sectors, and recognized that Illinois has not historically provided victims of harassment with adequate resources and recourse. As a result of the task force's work by meeting with various stakeholders, holding public meetings, gathering testimony and stories, both the House and the Senate issued recommendations and reports on next steps to take to address widespread sexual harassment and abuse. Public Act 101-0221 created the Workplace Transparency Act. Passed by the Illinois General Assembly this June 2019, and signed into law by the governor in August of this year, the legislation takes a number of steps recommended by both the House and Senate task forces, including the restriction of non-disclosure and non-disparagement agreements, language in employment agreements, separation agreements, and settlement agreements, restricting an employer's ability to require mandatory arbitration of sexual harassment or other discrimination claims, requiring annual sexual harassment training for employers in Illinois, and directing employers to report settlements and adverse judgments to the Illinois Department of Human Rights. As previously mentioned, Public Act 100-0762 created the continuing education requirement for all licensed professionals in Illinois by requiring a 1-hour sexual harassment prevention training as part of continued licensures and renewals. So what is sexual harassment? According to Illinois law, sexual harassment means any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when, 1, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, or 2, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting the individual, or 3, such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Please note, as part of this definition, working environment is not limited to a physical location an employee is assigned to perform his or her duties, and it does not require an employment relationship. This means that if an employee is operating out of the office or off-site, performing duties outside of the 4 walls of their typical office location, maybe an after-work event or working in a new location, the working environment covers those situations. Further, sexual harassment can occur when there is not an employment relationship present, meaning an employee's client or patient or a contractor can still be held accountable for their actions if committing inappropriate sexual harassment or advances. Harassment can include sexual harassment or unwelcome sexual advances requests for sexual favors, and other verbal or physical harassment of a sexual nature. It's important to note that both the victim and the harasser can either be a woman or a man, and the victim and the harasser can even be of the same sex. Also important to note, the harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who's not even an employee of the employer, like a client, customer, patient, or contractor. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal, and when it is frequent and severe, enough that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. So the forms and types of sexual harassment. The courts have defined two broad types of behavior that qualify as unlawful sexual harassment. Quid pro quo, or this for that. In quid pro quo sexual harassment, an employer or a supervisor makes submission to unwanted sexual advances or conduct an implicit or explicit condition of employment or employment benefits, or even uses such submission or refusal of sexual advances as a basis for making employment decisions concerning the victim. This includes things like hiring decisions, whether to hire, whether to promote, whether to give salary increases, what kind of work assignments, and performance reviews. To qualify as quid pro quo sexual harassment, the harasser must be in a position of power over the victim and have the authority to grant or deny the victim employment or employment benefits. One instance of this behavior may be enough to constitute sexual harassment, even if a threat is not acted upon. Conduct that falls into this category typically occurs when an employee or a job applicant suffers an adverse employment action like termination, a demotion, a pay cut, a rejection of employment for refusing to engage in unwelcome sexual activity. For example, when a supervisor threatens to fire an employee if he or she does not go on a date or otherwise engage in certain sexual acts with the supervisor has likely engaged in quid pro quo sexual harassment. The second type of behavior that qualifies as unlawful sexual harassment is called hostile work environment. And this kind of sexual harassment occurs when an employee is subjected to sufficiently severe or pervasive sexual offensive speech or conduct that it creates an intimidating, hostile, or offensive working environment, which affects the victim's job performance. Unlike quid pro quo sexual harassment, the harasser could be a supervisor or a coworker or even a non-employee like a client or a contractor. Examples of conduct that may create a hostile working environment include things like threatening comments or jokes, repeated sexual advances that impact the ability of an employee to do his or her job, such that it creates an intimidating, hostile, or an offensive working environment. Examples include verbal sexual innuendos, suggestive comments, insults, sexual language and jokes about sex, anatomy, gender, or gender-specific traits, sexual propositions, threats, repeated requests for dates, or statements about other employees, even outside of their presence, of a sexual nature. There are some nonverbal behaviors that could also create a hostile work environment, such as suggesting or insulting sounds like whistling, leering, obsessive gestures, sexually suggestive bodily gestures, catcalls, smacking, or kissing noises. Visual Examples of conduct that can create a hostile work environment include things like posters, signs, drawings, pictures or calendars of a sexual nature, or viewing pornographic material or websites. There are physical behaviors that can create a hostile working environment, like touching, unwelcome hugging or kissing, pinching, brushing the body, any coerced sexual act, rubbing of the shoulders, or actual physical assault. There are digital or electronic means of conduct and behavior that can create a hostile working environment. Things like sexting, electronically sending messages with sexual content, including pictures and videos, the use of sexually explicit language, harassment, cyber stalking, and threats via all forms of electronic communication. This includes emails, texts, and even social media. Whether the conduct is severe or pervasive enough to create a hostile work environment is very fact-specific and is determined on a case-by-case basis by the courts and administrative agencies. It usually takes more than one incident to create a hostile work environment, but the more severe the conduct, the less pervasive it needs to be. There could be a singular instance of conduct that is severe and could rise to the level of creating a hostile work environment. Ultimately, to be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to not only the victim, but also to any reasonable person. As we've mentioned, sexual harassment can be visual, verbal, written, physical, or typed. Anyone can harass, just as anyone can be the target of sexual harassment. This means regardless of sex, male, female, sexual preference, age, or professional position. It doesn't have to be a supervisor and a subordinate for it to be considered sexual harassment. And I think it's important here that we address, why do people harass? By and large, it's a form of expressing dominance or a power play or superiority by the harasser. Can also be used as a bullying tactic, can be used to organizationally or socially control someone. The harasser may have a desire to protect their turf or be attempting to seek peer approval. They also may feel free to harass because of the culture in which they are employed. So how prevalent is sexual harassment? Before we dive into this slide, I do want to note that these statistics are specific to women reporting sexual harassment, but as we know, men can certainly be victims of sexual harassment too. But according to the EEOC, or the Equal Employment Opportunity Commission's 2016 Select Task Force on the Study of Harassment in the Workplace, between 25 and 85% of women report having experienced sexual harassment in the workplace. And that number jumps to 60% when you ask whether the woman has heard sexist or crude language while at work. I think it's really important to note here that this was in the EEOC study was conducted in 2016, and this was even before the rise of the Me Too movement. So, before it was even popularized and considered mainstream to start talking out and reporting about these instances, women were reporting, between 25 and 85% of women were reporting having experienced sexual harassment in the workplace. Subsequently, at about the time of the first Me Too, #MeToo posts on social media, a poll by NBC and the Wall Street Journal in October of 2017 indicated that 48% of currently employed women in the U.S. report that they have personally experienced an unwelcome sexual advance or verbal or physical harassment at work. I also want to point out here that it's that these numbers are based on a survey of women who are willing to publicly report that they have experienced these situations. Some women who are interviewed may not be willing to publicly report, so these numbers may not be accurate. So here we're going to go through a few scenarios and test your knowledge of whether or not the situation fits the framework for sexual harassment, and if so, which type? Quid pro quo sexual harassment or hostile work environment sexual harassment. So the first scenario, Jason is an executive assistant working for Kate, a vice president. Kate asks Jason to stay late many nights to work on projects. Jason and Kate are friendly and sometimes even flirt a little. One evening, Kate tries to kiss Jason, but Jason turns away and explains that he does not believe it would be appropriate. The next day, Kate tells Jason about a job opening for him in another department and explains that she believes it would be a good move for him. So does this scenario constitute sexual harassment, and if so, which type? Quid pro quo or hostile work environment? If you answered yes in quid pro quo, you would be correct. In this instance, Kate is Jason's superior and is engaging in some inappropriate sexual advances. When Jason refuses Kate's sexual advances, Kate is taking and recommending employment decisions for Jason to move him out of his current position. So because Jason did not cooperate with Kate's sexual advances, Kate decided that it would be best for Jason to relocate and is making job decisions based on his refusal. Scenario 2. Dean has only worked for a company for a few months. He started hanging out with Jerry, Laura, and Tom after work. They had a few drinks, and Dean revealed something personal to the group. The next day at work, Dean walked in to find people around him whispering and laughing. Laura and Jerry told Dean that it was all in good fun and they didn't know it was a secret. The whole department now has an embarrassing nickname for Dean. Dean's work performance has now decreased significantly and he has used all of his sick days. Does this scenario constitute sexual harassment, and if so, which type? Quid pro quo or hostile work environment? If you answered yes, you would be correct. Hostile work environment. Even though the revelation of the personal information happened after hours, it was to coworkers, and the behavior of Dean's coworkers while at work has made Dean's work performance suffer. It was severe and pervasive enough to make Dean's work performance suffer, and therefore has created a hostile work environment for Dean. Scenario 3. Jessica is an employee that is friends with her boss, Tom. Every Monday, Tom comes into the office and chats with Jessica at her cubicle for about 30 minutes. Tom has a very active social life and always tells Jessica about his sexual encounters from the weekend. Does this scenario constitute sexual harassment, and if so, which type? Quid pro quo or hostile work environment? If you answered yes, hostile work environment, you would be correct. In this instance, Tom is Jessica's superior, and the inappropriate behavior is every Monday. It's unwelcome, and it's pervasive enough to create an environment in which Jessica does not want to work. Does this constitute sexual harassment? In this case, yes. It's inappropriate, unwanted behavior. Scenario 4. Rebecca has worked for Larry for over 5 years and has never received a raise or promotion. She works hard and has never had any disciplinary action, but every year, Larry gives an excuse. This year, Larry implies that she could do some extra credit and receive a promotion in 6 months. Rebecca really needs this promotion, so she does anything she can, including picking up Larry's dry cleaning and bringing it to his house. When she arrives at Larry's house, he thanks her and asks her to stay for dinner. During dinner, Larry never once makes eye contact with Rebecca, but instead stares at her breasts. At the end of dinner, he tells Rebecca that she is very pretty and that she should wear more low-cut blouses at work. Does this constitute sexual harassment, and if so, which type? Quid pro quo or hostile work environment? If you answered yes, quid pro quo, you would be correct. In this scenario, Larry is Rebecca's superior, and Larry is making a condition of a salary increase on Rebecca's willingness to perform extra credit. And in this instance, the extra credit means things like wearing more low-cut blouses to work. Larry's making employment decisions based on sexual favors and sexual behavior. In the last scenario, scenario 5, Jonathan goes to the company gym with his coworkers, Adam and Kevin, every day at lunch. After working out, they shower and change in the locker room. One day, Jonathan goes to his boss and tells him that Adam and Kevin keep making crude jokes and trying to grab his genitals while they are in the locker room. Jonathan's boss tells him that they are just being guys messing around, and that if it offends Jonathan, he should just go to the gym at a different time. Does this constitute sexual harassment? And if so, which type? Quid pro quo or hostile work environment? If you answered yes, hostile work environment, you would be correct. In this instance, Jonathan, Adam, and Kevin are all co-workers. There's no superior involved here in the inappropriate behavior. When Jonathan tries to report it to his boss takes no appropriate action. And Adam and Kevin have kept these jokes and crude behavior and crude actions that are considered pervasive and offensive enough to create a hostile work environment for Jonathan. So now that we understand what sexual harassment looks like, how should you respond to sexual harassment if you are a victim or a witness? So how should you respond to sexual harassment? You may find yourself in a position in your place of employment where you are the victim of sexual harassment or you are a witness to sexual harassment of other colleagues in your workplace. It's important to acknowledge that you may feel many different kinds of emotions. You may be shocked at the behavior, angry, embarrassed, anxious, and scared. First and foremost, you need to tell the harasser to stop. Being specific and very clear about the behavior that is making you uncomfortable is very important, and do not be apologetic when you tell the harasser to stop. You should also document everything about the incident or incidents. You want to be sure you record the date, the time, location of the incident, what happened, what was said or done, and who witnessed the behavior. You want to keep copies of any relevant evidence like emails or texts or photographs that support your account of the incident. It's also important to note here that you may want to consider documenting in a non-electronic or technological means. Sometimes computers crash, and you don't want to lose all of the information that you've documented if there is a technical glitch that causes you to lose files. You may also not want to document this information on your work computer. You may want to consider writing it down on paper and taking it home with you, or using a home computer with a backup system to document the behavior. You want to retain records. Keeping copies of your work records, like your performance evaluation, any memos or letters or feedback from your superiors. Your harasser may try to defend himself or herself by attacking your job performance. So you want to make sure that you have evidence of your performance in your work and your records, your reputation, and the quality of your work. It's also important, especially for an instance of hostile work environment, if you are suffering mentally, emotionally, physically from the harassment, to keep evidence of how you're suffering, whether it's your employee performance, or other factors that you can keep hard copies of. I think it's also important in terms of quid pro quo harassment. You want to be sure that if you choose to report a superior, that superior isn't going to turn around and say that that you are just responding to a poor performance evaluation. So you want to make sure that you keep copies of all of your work-related records to help bolster your position. You'll also want to tell a trusted friend, a family member, or a trusted coworker. They can provide you with support, emotional, mental, physical support to work through what happened. They can also provide corroborating statements if necessary. So if you do choose to report the harassment, these people can be interviewed and can corroborate your story. Further, you should determine your goal or your ideal outcome. Do you want to remove the harasser from his or her position in the company? Do you want to remove the harasser from the company, period? Do you just want the harassment to stop so that you can do your job? Is your goal, because the harassment is so severe and pervasive that you've suffered financially? Maybe you're looking for compensation for lost earnings and emotional distress. So you need to really think about your ideal outcome and your goal. You're also going to want to review your company policy. It's very important that you understand what the policy is, what employees are expected to do if they experience or witness harassment, and how to report it internally within the organization. If you do choose to report, you should definitely follow the guidelines of your company policy very closely. You want to be sure to familiarize yourself with the statute of limitations. Many people who experience harassment are, either embarrassed or anxious or scared to come forward, and it may take a little bit of time for them to work up the courage to come forward and to report. But it's very important that you note the statute of limitations. So under state and federal law both, complaints to government entities like the Illinois Department of Human Rights and the EEOC on the federal level have to be filed within 180 days of the incident. You may also consider talking to a lawyer. Not always is it especially fruitful or the perfect solution to file legal actions in response to sexual harassment, but consulting an attorney is never a bad idea in these situations. So, it could be difficult to find an attorney, especially difficult and expensive. You may need to hire them on a contingency basis, meaning that the attorney only gets paid if you win the case, and money is recovered from your employer. However, you need to note that lawsuits are very time-consuming, expensive, and emotionally draining. If you're unable to obtain relief by confronting the harasser or pursuing the procedures of your organization, taking legal action may be your best recourse. Just because you talk to a lawyer and get advice from a lawyer does not necessarily mean that you have to file a lawsuit. You should also consider what to expect after you report the harassment. Make sure you know how you're going to feel, or think about how you might feel physically, mentally, emotionally after you report. Sometimes people think if I say it out loud, I get it off my chest and that will make me feel better, which can certainly be true for some, but for others, it could be completely the opposite. So you need to think about how you're going to feel and how other people, including your coworkers, your friends, and your family, may react. Just making sure they're going into this eyes wide open. You need to determine what action you're going to take. If the sexual harassment is criminal in nature, if you've been assaulted, if you've been raped, you need to report the incident to law enforcement immediately. If it's less severe and you choose to report the harassment to your supervisor or another superior, you need to make sure that you know your company policy and you follow the protocols in that policy very carefully. And further, if you choose to report to an outside entity outside of your place of employment, a government entity like the Illinois Department of Human Rights or the EEOC, you need to follow the steps to file a charge very carefully. And lastly, you're going to want to continue to document everything. So not just about the incident or incidents when they occurred, but you also want to document all of the communication that you've had with your supervisor, your superiors, your HR department, anyone within your organization that you've told about this, that you've reported the harassment. You need to record those conversations and what actions they took following your report. So how do you go about reporting sexual harassment if you've been the victim or a witness? So first and foremost, from the EEOC, employers should really focus on preventing sexual harassment from happening in the first place. They provide some guidelines that encourage employers to take all steps necessary to prevent sexual harassment from occurring. Things like affirmatively raising the subject, talking about sexual harassment and ways to prevent it, creating a culture of accountability, letting all of the partners in the organization know that they are accountable for their behavior, expressing strong disapproval of this kind of behavior, that it's not acceptable at work, developing appropriate sanctions, making sure that people are dealt with and punished appropriately for their inappropriate behavior, informing employees of their right to raise and how to raise the issue of harassment, so making sure it's widely known the avenues for reporting, and developing methods to sensitize all concerned. So, talking about sexual harassment as an issue, making sure that people know, conducting regular training sessions. These are all things that can help sensitize and encourage a culture, a positive culture. So what can you expect of your employer in terms of remedial actions once you file a complaint, once you make a report about harassment, whether you're the victim or a witness to the harassment? Your employer should investigate promptly and thoroughly. So they need to take your report, your complaint seriously, and investigate the report or complaint in a timely and thorough manner. They need to take immediate and appropriate corrective action by doing whatever is necessary to end the harassment. So first and foremost, your employer needs to make sure that you're safe and you feel safe at work. They should also make you whole by restoring lost employment benefits or opportunities. So, if it's an instance of quid pro quo sexual harassment and you were denied a promotion because you refused your supervisor's sexual advances, your employer should take that into consideration when looking to restore, the promotion or the lost wages from that promotion. And importantly, they need to ensure that the misconduct does not happen again, either from that harasser individually or from other employees within the organization. Disciplinary action against the offending supervisor or employee can range from reprimand to discharge. Generally, the corrective action needs to reflect the severity of the conduct. The employer should also make follow-up inquiries to ensure that the harassment has not resumed and that the victim has not suffered retaliation. The retaliation piece is huge. Retaliation is illegal, and your employer should take steps to ensure that after you report an incident or extensive harassment, that no one within the organization is retaliating against you for that report. So what else can you expect from your employer after you report? They should, and they will likely initiate an investigation. As part of that investigation, they're going to interview the victim of the harassment. They're also going to interview the harasser. They're going to interview any witnesses. They're going to attempt to obtain any corroborative evidence. So this is things like pictures, emails, text messages, social media posts, documents, any evidence that exists that would corroborate the story or the report. And then the employer, if the investigation is substantiated, needs to take appropriate action. As previously mentioned, the corrective action should generally match the severity of the harassment, and so that could range anywhere from suspension all the way to being fired. So if you report, you should definitely be prepared to answer the following questions as part of your employer's interviewing process. And if you follow the recommendations from earlier, you should have all of these things documented already. Where did the behavior occur? Who was involved? Were there any witnesses to the behavior or the incident? Did you tell anybody else, any coworkers, any friends, any family members about what happened? Has this happened before? Is this a pattern of behavior or is this a one-time incident? How long has it been going on? Was the person told that the behavior was unwelcome? Did the victim or did any witness tell the harasser that the behavior was inappropriate and that he or she should stop? So it's important to note that outside of your organization or your place of work, your employer, there are avenues for reporting harassment to governmental entities. Generally, you should file a complaint or a report with your employer prior to filing a complaint or a charge with a governmental entity. But in Illinois, the Human Rights Act prohibits sexual harassment in the context of both employment and in education. And in our state, the Department of Human Rights is charged with investigating claims of sexual harassment, while the Illinois Human Rights Commission is the administrative adjudicatory body that resolves cases involving sexual harassment. It's important to note here that you have 180 calendar days from the date the harassment took place to file a charge with the Illinois Department of Human Rights. If you choose to do that, beyond filing a complaint or a report beyond your employer, you can reach the Illinois Department of Human Rights through the helpline 1-877-236-7703. You can visit one of their offices. There's one in Chicago, one in Springfield, or call them at the office. You can also email them at the address listed on your screen. At the federal level, the Equal Employment Opportunity Office, or EEOC, is charged with enforcing the federal equivalent of the Human Rights Act, which is Title VII of the Civil Rights Act of 1964. The EEOC's job is to receive, investigate, and pursue appropriate legal recourse in cases of sexual harassment under federal law. In many cases, both federal and state law apply. This has led to a situation where state and federal agencies have a work-sharing agreement that outlines how each agency handles the intake of claims in cases that both federal and state laws apply. The complainant can then choose the forum, either state or federal, in which to pursue their claim or their charge, their complaint. This is the information on reporting a complaint or filing a charge with the EEOC. You can do this if you believe you've been discriminated against at work because of race, color, religion, sex, including pregnancy, gender identity, sexual orientation, national origin, age, disability, or genetic information. A charge is essentially a signed statement asserting that your employer, a union, or labor organization engaged in employment discrimination, and it requests that the EEOC take remedial action. Again, like the state, you have to file a charge with the EEOC within 180 calendar days from the date the discrimination took place. And to do that, you visit their public portal where you can log in and file a charge with the EEOC at publicportal.eeoc.gov. So if you choose to report either as a victim or a witness, are you going to be protected against retaliation for being a whistleblower? The short answer is yes. So in 2004, the Illinois General Assembly passed the Illinois Whistleblower Act, which prevents employers from retaliating or threatening to retaliate against employees for disclosing certain information in certain instances. So employers are prohibited from enacting certain policies that would prevent employees from disclosing information to a government or law enforcement agency if that employee has reasonable cause to believe that the information discloses a violation of state or federal law, rule, or regulation. Employers cannot retaliate against employees for these disclosures. Employers are prohibited from retaliating against an employee who refuses to participate in an activity that would result in breaking the law. Employers also cannot threaten retaliation for reporting. And if an employer does violate the terms and provisions of the Whistleblower Act, it will be considered a Class A misdemeanor. And the employee has a right to bring a civil suit against the employer for reinstatement of their position with the same seniority status, for back pay with interest, and for compensation for any damages sustained as a result of the violation. This includes things like litigation costs, expert witness fees, and reasonable attorney's fees. Just to be very clear about what retaliation looks like, it's any act of revenge or backlash against someone who has reported sexual harassment. This includes any negative act as a result of the complaint. Examples of retaliation include things like mistreatment, insults, mockery, bullying, gossip, threats, poor performance evaluations, denying raises or promotions, sabotage of work, reassignment, forced unpaid leave of absence, firing, or even assault. So now we're going to go over a few things that help encourage a positive workplace culture and best practices in the workplace. It's important to note that all employees play a part in creating and maintaining a positive workplace culture. So this doesn't necessarily come from the top down. It can be a bottom up culture, that is really created and maintained by the rank and file employees and not necessarily by the leadership, but it works best when it's encouraged and supported by the leadership of an organization. A positive culture means that we're all held accountable for our actions, that we're good coworkers, we're good humans. We stand up for what is right and we condemn what is wrong in the workplace. We must be held accountable and we cannot tolerate inappropriate behavior in the workplace. It's important to note that the primary goal of every workplace should be prevention of sexual harassment. This is also, direct guidance from the EEOC. While it's important for employers to have policies and procedures on how to respond to incidents of sexual harassment, there should also be policies and procedures in place that the sole goal is to prevent sexual harassment from happening in the first place. In order to do this, every workplace should establish and regularly review and update sexual harassment policies. This really gets to the sensitizing everyone in the workplace, making sure that sexual harassment is talked about, that it's condemned, and that everyone is on the same page about what's appropriate and inappropriate behavior in the workplace. To accomplish this, every workplace should provide regular training on sexual harassment, not just a one-time training. So it's important that people are refreshed, that they get information that they need, and that it's reinforced what kind of behavior is appropriate and what kind of behavior is inappropriate in the workplace. To summarize and provide a few key takeaways of today's presentation, we're going to quickly do a couple of true-false questions to make sure you understand some of the concepts. So true or false, it is only considered to be sexual harassment if the incident involves some sort of physical touch. Is that statement true or false? If you answered false, you're correct. Sexual harassment includes any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature. It can be verbal, visual, physical, written, or typed in form. True or false, it is only considered to be sexual harassment if the behavior involves a supervisor and his or her subordinate. False. A harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not even an employee, like a client or a customer. True or false, it is only considered to be sexual harassment if the incident occurs within the walls of the office or working environment. False. For purposes of employer responsibility in cases of sexual harassment, working environment is not limited to a physical location. An employee is assigned to perform his or her duties and does not require an employment relationship. A few more key takeaways from today's presentation. Sexual harassment is wrong and cannot be tolerated in the workplace or in everyday life. We all should establish a positive workplace culture focused on prevention of harassment. Sexual harassment comes in various forms, including quid pro quo and hostile work environment. Anyone can be a harasser, just as anyone can be a victim, regardless of age, sex, position in the company. If you're a victim of sexual harassment or a witness to sexual harassment, you should take certain steps to remedy the situation, including filing a complaint or a report with your employer and potentially involving outside governmental entities. You should also know that any sort of retaliation for reporting sexual harassment is illegal. Thank you for participating in today's webinar. Please be sure to complete the quiz following this presentation and complete the evaluation for your continuing education credits. Remember This course, a 1-hour course, is required as part of your continuing education for your licensure renewal. So make sure to complete the quiz and your evaluation in order to receive your continuing education credits, which are required as part of your licensure renewal. Thank you for your participation.